Hello, and welcome to a session on media law and legal issues journalists should know. My name is Dr. Rebecca Tallent, and I'm a member of the Society of Professional Journalists Journalism Education Committee. Before we begin, just a quick word. This is a basic primer about important issues for student journalists. It is not intended to be all-inclusive. When in doubt, please check with either SPJ or the Student Press Law Center. So let's begin. The first case all student journalists should be familiar with is the Tinker case, decided by the U.S. Supreme Court in 1969. Tinker did not specifically address journalism, but rather freedom of speech for students. This case began in 1965 when Mary Beth Tinker, then age 13, plus her brother and a friend, silently protested the Vietnam War by wearing black armbands to school. The Des Moines Independent School District principals had decided students could not wear the armbands, and as a result, the 3 students were suspended. The Tinker family sued, and the U.S. Supreme Court agreed with the family. In their 7-2 decision, the High Court said Tinker had the right to silently protest. In addition, the court specifically said it could hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. Now, this expression, right to opinion does not stop at the schoolhouse gate, has been widely quoted by numerous court cases. Now, following Tinker, another very important case for student journalists is the Hazelwood case, Hazelwood versus Kuhlmeier. In this case, students at Hazelwood East High School in St. Louis, Missouri, prepared their paper for publication with stories which contained one about unwed pregnancies and another about divorce. Now, the students used false names and obscured the real names of the people quoted. However, the principal removed the stories from the newspaper, saying the students could be identified. The student editor, Kuhlmeier, sued. The U.S. Supreme Court said the case came down to whether or not the high school journalism class preparing a publication as part of an educational plan could be considered a public forum or speaking for the school district. The court debated the idea, and in the end, the court said because the newspaper was part of an educational exercise, the teacher was paid by the school district, the school board paid for the printing cost, the newspaper was circulated throughout the community, and as a practice, the advisor submitted pages for review. As a matter of practice, the newspaper was indeed a public forum, and that the principals or school administrators have the right to regulate content or censor in any reasonable manner. This obviously in 1988 brought a very chilling effect to high school journalism. So what's the difference between these two very important cases? The differences at first seem very similar, but actually they are quite different. They both deal with student voice. And Tinker asked whether a school official can censor a student's right to personal expression at school, and the court said that they could not. Whereas Hazelwood asked whether a school may censor speech at a school district supervised event, in such a way that the public may perceive it as being sanctioned by the school. And in this case, the Supreme Court ruled that schools do have the right to censor. Now, since Hazelwood, something very interesting has happened, and that is, since 2013, several states have passed what's known as New Voices legislation, which has reversed Hazelwood on a statewide basis and reestablished student press freedom. This began in the state of North Dakota, and as of early 2020, the states currently allowing student press freedom that we had pre-Hazelwood include North Dakota, Arkansas, California, Colorado, Illinois, Kansas, Maryland, Massachusetts, Nevada, Oregon, Rhode Island, Vermont, and the state of Washington. Many other states are also considering legislation. Please check to see if your state is also considering New Voices legislation. There are several other very important laws for student journalists to know. And the first, of course, is the First Amendment. The First Amendment guarantees us the right to 5 specific freedoms: speech, press, religion, to address the grievances with government, and to peacefully protest. This is the cornerstone of American journalism because it does guarantee the freedom of press and freedom of speech. Another set of laws that's extremely important for student journalists to know and understand are public records laws. Public records laws are available in each state, and they're also known as sunshine laws. There are 2 generally, open records and open meetings, but the granddaddy of them all is on the federal level, and that's the Federal Freedom of Information Act, which was originally passed in 1966, and it was followed in 1996 by the Electronic Freedom of Information Act. The original act only dealt with paper products. The Electronic Act allows journalists to look at databases, or anyone actually, to look at databases, to look at text, emails, anything that is not in paper form. Many states had open records and open meetings law prior to 1966, but since 1966, many have added them. And again, these are sometimes called sunshine laws because they allow the public to view the public's business and understand what's happening in agencies and commissions. Now, a word of caution is that these laws do have exemptions, especially on a state law, which means they are not always so public. A common thing you will find across the board in every state is that police departments are exempt from the Open Records Act for ongoing criminal investigations. And once the investigation is finished, then those records can become public, but while they are ongoing, they cannot be released. So it's, while journalists are not real happy about that, we know we can eventually get to them. So please take a look. You can look up your state open record and open meetings law. Each state is different, and so I recommend that you do check these out. Now, 2 more very important laws for journalists to know. First is defamation, and defamation has a very specific meaning. And you need to know it's divided into 2 parts. It is called libel when it is usually a written defamation, and it is slander generally if it is spoken. Now, you have to remember, this is anything that is not completely true that is said about someone. A key thing to remember is that identification of the person being slandered or libeled must be clear. This can be their name, a nickname, a photograph, or an illustration. It can be through reference or through a specific context, meaning reporting information which makes the person in a way that makes the person identifiable. Do not think for a moment that the person telling you the false information is the person most liable. If you report it without checking it for truth, you are also liable. That being said, I will say that not all false information published is libelous, but a reporter should never, ever knowingly publish false information regardless of the severity of the damage it might cause. Always make sure that your information is true. Journalists do have limited protection in defamation cases, but that is only if the reporting is accurate. They accurately reported what somebody else said. Another thing that is very important is copyright. This is the exclusive right for someone to print, publish, perform, film, or record literary, artistic, or musical material and to authorize others to do the same. So this is a legal right of the person to hold this information. So to cut and paste an article or information from the internet is often a copyright violation. The same is true for using words from a song or images from a film and broadcast piece. To do this without written permission from the copyright holder is against the law. I will tell you it is generally very easy to get copyright permission. You simply have to contact the person who holds the copyright, whether it be the author or the songwriter or the film's producer, to get written permission. And an email written permission is always perfectly acceptable. These are the key laws that all journalists must know, student or not student. And by the way, a student journalist is a journalist. And so some other things to always keep in mind. All journalists must always remember that when you are reporting, your reporting should always be fair and it should always be accurate. That you must understand that what you have a right to report and what is right to report are not always the same thing. And finally, journalists don't get special privilege. Laws regarding publishing and access to government information apply to everyone. We just happen to use them more than anyone else. If you need more information or if you need additional resources, two great resources. The Student Press Law Center at splc.org. They have a staff who deals strictly with student journalism, and they are very, very well versed in the legalities of student journalism. And also the Society of Professional Journalists at spj.org. Again, staff totally dedicated to all things journalism and wanting to make sure that we can do our jobs correctly. Thank you so much for spending time with me. I appreciate it. If you have any questions, please ask SPJ or the SPLC.